Okay, everybody, it's 12:05. I think it's a great time to get started. Today, as you all know, we are here to learn about fair housing. We are very blessed to have two incredible human beings from Prairie State Legal Services. We, of course, have Jennifer and then Maya, both from Prairie State. I'm going to let them introduce themselves. Just as a reminder, everybody is muted during the presentation because there will be a Q&A session at the very end. If you do want to just grasp onto that question, you can put it in the chat, or you can just wait to ask the gals the questions until later on. But that being said, I'm very excited for today's presentation. Without further ado, Maya Jennifer from Prairie State.
Thanks, Liz. Jen is going to take the first part of the presentation, but I'm going to be sharing my screen the whole time. So let me just go ahead and do that. And how's that? Can you see my screen? I think you should be able to. Looks good. Yeah. All right. Well, then I'm going to turn it over to Jen, my colleague.
Hi, everyone. I'm Jennifer Cuevas, the Testing and Outreach Coordinator here at Prairie State Legal Services. We'll talk about testing here a little bit later on. But at first, I'm going to give you a little information about Prairie State Legal Services. And then Maya will give you a bunch of information about fair housing. Our mission here at Prairie State Legal Services to ensure equal access to justice and fair treatment under the law by providing legal advice and representation, advocacy, education, and outreach that serve to protect basic human needs and enforce or uphold rights. There are 11 offices and we cover 36 counties. So basically the top half of Illinois, excluding Cook County or Chicago. And we serve many, many clients. Some of the examples of clients that we serve are adults over the age of 60, persons with disabilities, survivors of domestic violence, individuals with limited income, and veterans. One of our requirements is that we need our clients to be a U.S. citizen or a lawful permanent resident due to our restrictions. But many times we have ways to help anyway. We can use certain documented immigrants that have asylum seekers or maybe are victims of domestic violence or human trafficking. We can still assist. So some of our goals here at Prairie State is the safety, the well-being through housing and financial stability of our clients. And now I'm going to turn it over to Maya. She's going to do some, oh, whoop, there's one more screen, sorry. So some of the cases that we take here at Prairie State, domestic violence. So we do orders of protection, divorce, and housing issues. Medicare, Medicaid, and other healthcare issues, elder abuse and financial exploitation. We help with loss of or denial of public benefits. That includes SSI, SNAP, TANF, VA, Medicaid, or housing vouchers. We assist with evictions, landlord lockouts, and habitability issues, utility disconnections or denials, Social Security, consumer debt and collection issues where income or assets are at risk garnishment, and sealing and expungement of criminal records. And of course, we do fair housing work and housing discrimination as well. Now I'll turn it over to Maya to discuss the fair housing.
Thanks, Jen. As Jen said, or I guess Liz said, my name is Maya Zabel. I am an attorney at Prairie State Legal Services. I do all housing law, but my area of expertise and my focus for a little over 10 years now has been fair housing, which is why I'm with you here today. My name and my contact information, as well as Jen's name and contact info, will be at the end of the presentation. That'll be on one of the last slides too. And like Liz said, we're not gonna take questions in the middle of the presentation, but I'll make sure that there's time at the end of the presentation to answer some questions. And if we don't get to your question, then you'll have our contact information as well. Since I'm sharing my screen, I won't see the chat too, so I apologize, but I promise I will take a look once I'm done. So just to give you a little roadmap of our next hour and 20 minutes till 1:30, we'll make sure you are out in time. I'm going to give you guys an overview of fair housing. What are the different protected classes? What discrimination can look like. We'll talk about a few of those protections in a little more detail. We'll spend a little bit of time talking about the additional rights of people with disabilities in housing, because that's a really relevant area of fair housing that comes up a lot in my work, and I think comes up a lot just in general. And then Jen is going to talk about testing, and our testing program is one way that we do investigations into housing discrimination, and how you could get involved in that if you are interested in, but no pressure. So anyways, with that, I will get started. What is fair housing? I'm sorry if Liz mentioned this or at the beginning, but we're talking about this month in April because April is National Fair Housing Month. And the reason April is National Fair Housing Month is because it was in April of 1968 that the Federal Fair Housing Act became law, was signed into the law. And the federal law, like I said, the Federal Fair Housing Act is what protects people against discrimination in housing. And it really protects people in all areas of housing. We work at Prairie State mostly with people that are in the rental context. So with people that are renters, that are potentially experiencing discrimination in the landlord-tenant context, but it really can come in all different forms in the housing industry. But like I said, because we work mostly with renters, most of the examples we'll give will be talking about it in the rental context. But anyways, under the Federal Fair Housing Act, it says it is the policy of the United States to provide within constitutional limitations for fair housing throughout the United States. And then in Illinois, we have our additional protections. Besides the federal law, we have the Illinois Human Rights Act. And under the Illinois Human Rights Act, it says about fair housing. And of course, both of these laws are a lot longer than just what's on these screens. But it says that fair housing means freedom from discrimination against an individual because of his or her protected characteristic in connection with a real estate transaction. And that's really that key piece there, I think, when you think about what discrimination is in housing and what illegal discrimination is in housing, what's a violation of the law, is it has to be somebody being treated differently because, number one, because of their protected characteristic. And I'll tell you in just a minute what those protected characteristics could be. So someone's being treated differently because of a protected characteristic, and it has to be in a real estate transaction. And a real estate transaction can mean, like I said, we talk about it a lot in landlord-tenant context, but there's other examples as well. And I can't remember if I put this slide in or not, so I will just share it right now about what some other examples are. Besides landlord-tenant law or landlord-tenant relationships, other people that can't discriminate against are, other people in housing industry, banks that give out mortgages, insurance companies that give out home insurance or renters insurance, people that sell their properties, realtors, housing authorities, management companies, etc. But anyways, so these are the laws that we're talking about today. So at its core, like it says there at the bottom, fair housing means equal access to housing a person chooses, free from discrimination, making sure that people have the same access to housing regardless of their protected characteristics. So before I tell you any more, do you think, we have two polls in this, and there's no right or wrong answer here. It's really just to give me a little bit of a sense of how you're feeling or your opinion on these things. Do you think that housing discrimination still happens today? Yes, often, yes, but rarely, not really, or unsure. So I am going to ask that the first poll be launched, please.
Oh, done. And we're already getting some answers in.
Oh gosh, okay.
Folks
See,
have answered. 13
awesome.
people. And the majority of folks, 87% think that yes, it often does happen. 7% thinks, yeah, but rarely. And then 7% think, not really. So not one person has said unsure, but the majority are saying yes, it often happens.
Thanks, Liz. I like I like that. I like that we got that, that there were some fast responses there. I appreciate that. So yeah, like I said, there's no wrong answer here. I do think that it definitely does happen. Whether it happens often or not, I think it depends on where you are. I think that's a broad question. Like I said, there's a lot of different contexts, and it's a big country, so it can be different depending on where you are too. But I do think it still happens, and that's why we're here today to maybe you aren't sure if it's happening, and so I'll tell you a little bit more about it, so that maybe something that you didn't realize was discrimination, you can be more aware of it now in case you see something happening to you or somebody you know, or you've heard about it, and then you'll remember this conversation that we're having today, and then you'll think, okay, well, maybe this is a potential fair housing issue. So, like I said, fair housing means being free from discrimination, regardless of, or being treated equally, regardless of your protected characteristic. Housing providers cannot treat people differently based on certain protected characteristics, or what we call in the law protected classes. And there are different protected classes in the federal law, in the state law. There's even laws further down in different municipalities. Certain cities have fair housing ordinances, or certain counties have fair housing ordinances with additional protections too. But today we're just going to be talking about the federal law and the state law in Illinois. Under the federal law, under the Federal Fair Housing Act, housing providers cannot discriminate based on these 7 protections, these 7 protected classes. They can't discriminate based on someone's race, someone's skin color, someone's religion, someone's sex, nationality, familial status, or their disability. And now I have I think I have a slide on each one of those, so I'll just tell you just a little bit more about each one. So I think some of them speak for themselves, but a little bit more on some of them. So disability, we're going to talk about a lot more in the second half of my presentation today, because people with disabilities have some additional rights that the other protected classes don't have. Disability was the newest protected class added to the federal law in 1988, and disability protects people with both physical or mental disabilities. Protects them against housing discrimination. Race and color are 2 different in the law. It says race and color separately. We often might think of them as one and the same, but they're not. And in the law, they are separated into 2 different definitions. And I think that's because sometimes discrimination based on color can be a little bit more nuanced, where 2 people are of the same race, but a landlord might discriminate against them because of their their color, even though they are technically of the same race. So maybe lighter skinned versus darker skinned, but again, technically the same race, but different colors. So that's why I think there's that difference in the definition, although a lot of times they can be used interchangeably as well. Sex is another way to say gender discrimination based on someone's gender. So sex or gender. So based on that, so treating someone differently, being male or female at the federal level. We have some additional protections at the state level that go into this in a little bit more detail, which I'll touch on in just a few minutes. Sexual harassment is something I wanted to put a slide on just on this, because sometimes people don't think of sexual harassment as a type of discrimination. But sexual harassment is a type of discrimination that falls under that umbrella category of discrimination based on sex. And it's where there's, you can see here, there's two different columns here. It kind of falls into two different subcategories. There's quid pro quo or hostile environment. So quid pro quo, an example is literally means something for something else. So an example is requiring a sexual favor in exchange for a housing benefit. Like maybe a landlord is offering to knock the rent price down if someone, in exchange for sex from a tenant, they're offering free rent or a rent reduction for that. That's quid pro quo. That's a type of sexual harassment. Or a hostile environment. And that can be a lot of different things: inappropriate or unwanted touching, harassing language or comments. It has to be severe or pervasive, like pretty much everything in the law. Those are very case by case specific terms. But what it basically, generally means is that sexual harassment, hostile environment has to either be severe, rising to like a certain threshold of egregiousness, or pervasive, meaning like happening pervasive, right? More than once or often or something like that. And like it says here it applies to anyone, an employee, a maintenance person, a receptionist. That really goes for anything in fair housing discrimination, that anyone that works for a landlord or a housing provider has to follow these fair housing laws. So everyone involved in a management company, for example, from the owner of the company or the owner of a property down to a receptionist, a maintenance person, anyone in there that is part of that company or an employee is also has to follow these laws. It can't discriminate. All right, the last few protections at the federal level, we have religion, which I think that one speaks for itself, right? Cannot discriminate based on someone's religion, someone's national origin, and that can mean where someone was born, where their ancestors are from, someone's ethnicity. It can sometimes mean treating someone differently because of the language that they speak. And it can also mean not just treating that person differently because of their own national origin, but maybe it's someone else in their family, right? And it says there, that last bullet, immigration status doesn't affect coverage, because regardless of someone's immigration status, everyone is protected under fair housing laws. Housing providers cannot discriminate against anyone, and everyone has the right to be treated equally in housing and not be discriminated against regardless of their immigration status. And familial is the last one at the federal level. Again, this was added at the same time as disability in 1988 to the federal law. It protects people with children under 18 in their household. And it also includes protections for pregnant women or anyone trying to get custody of a child. I think the time it comes up most often is for families with children under 18 in the household. So, maybe a landlord treating a family different with children than a couple that doesn't have children for some reason. protects families with children under 18 in the household. All right, I mentioned there's also this Illinois law, the Illinois Human Rights Act. The Illinois Human Rights Act, in Illinois, all those things that I just talked about are good law, right? It's federal law. Those are all protections that we have in Illinois that protect us against housing discrimination, but we also have additional protections. Under the Illinois Human Rights Act, housing providers in Illinois also are not allowed to discriminate in housing based on, we have a lot more protections: age, military status, marital status, protective order, pregnancy, arrest record, sexual orientation, source of income, immigration status, and reproductive health decisions. And I believe I have a slide on each one of those. Age. Sometimes I don't have a poll on this today, but sometimes I like to have people guess, or if I'm in person with people, what's the age of what age does the law in Illinois protect people from in age against discrimination based on age in Illinois. So landlords in Illinois can't treat people differently who are age what and older. And a lot of people usually guess 65 or 18, both logical guesses, or 60, another logical guess, which are all good guesses, but not the correct guess. So in Illinois, it's 40. 40 is the age. And so in Illinois, landlords and other housing providers, I'm sorry, I have a habit of saying landlords because, like I said, it just comes up the most often in my work in the context of working with tenants and renters. But remember, in the back of your head, there's other people that can't discriminate, but I'm just going to most probably use the word landlords mostly when I'm talking today. Landlords can't discriminate based on someone's age, so they cannot treat people differently who are age 40 and older. If a landlord doesn't want to rent to people who are in their 20s because they think that people in their 20s are maybe a stereotype that they're louder or something, or that is not age discrimination, because in Illinois, landlords only cannot discriminate based on people 40 and older. So if a landlord doesn't want to rent to people because they are older than 40 or in their something older than 40, that's a protection that in Illinois. Marital status. So that means that providers in Illinois cannot discriminate in housing based on whether someone is married or single. So for example, if a landlord says you have to be a married couple to live in my property, and there's a couple that comes there, they're not married, but they want to rent there, and the landlord says, no, I only rent to couples that are married, that is marital status discrimination. Military status protects people who are active duty in the reserves, veterans, and it also protects people based on their discharge status, including unfavorable discharge. So housing providers who are treating people differently because of their military status, that is a type of housing discrimination in Illinois. We also have a protection in Illinois for order of protection. So this is for the person who has the order of protection. This is for the protected party. So if someone has a order of protection against somebody else, the person that it's against is not protected here. It's for the person who has that protection. So if someone has a protected or an order of protection, or sometimes called a restraining order, against someone based on any of these types of orders, based on the Domestic Violence Act, criminal procedure, stalking no contact order, civil no contact, or out of state protection, landlords can't treat people differently based on that. And I've seen that, sometimes you hear that come up with like a landlord that might say, well, they hear that somebody has an order of protection and they don't want to rent to that person because they assume that because they have an order of protection that will maybe bring crime to the property. Or someone is already renting there and then they have an order, and then maybe there is some kind of domestic violence issue, and then one of the tenants gets an order of protection against someone else, against maybe the other person that they're living with, and then the landlord decides to evict both of them, well, only the person that has the order of protection is protected if the basis for that eviction is because of that order of protection. Pregnancy is another one we have. And if you'll remember when I talked at the federal level about familial status discrimination, at the federal level, we have that protection that protects people with families with children under 18 in their household. It also protects people who are women who are pregnant. So we do have that protection already at the federal level, but also in Illinois, it says it explicitly that there's also a protection for people based on pregnancy. So housing providers cannot discriminate based on someone because of their being pregnant. Sexual orientation is another one we have in Illinois, and so that protects people based on their sexual orientation or their gender identity. So that's a protection that we have in Illinois as well. Arrest record is one of our newer protections. That became part of the Illinois Human Rights Act in 2020, so only about 6 years old now. So that the way that arrest record is defined in the Illinois law is that it's arrests that don't lead to convictions, juvenile records, or records that have been expunged or sealed or impounded. So it says here, as you can see, landlords cannot consider arrest records in housing decisions. And the key here is it's arrests that don't lead to convictions. So there are some places in the country that have broader protections, maybe where landlords can't discriminate against people because of any kind of criminal history or criminal record. In Illinois, we don't have that broad of a protection. We do have a protection, but it's only for arrests that didn't lead to convictions, or if it's a juvenile record or a record that's been expunged or sealed. So landlords can run and routinely do run background checks, right? And those background checks will often pull someone's criminal history. And so a landlord just looking at someone's criminal history when they're making a decision in Illinois is not in and of itself discrimination under the Illinois law. If a landlord made their decision because of someone's on their criminal history, there were arrests, but that didn't lead to a conviction. So maybe the person had a trial and the case was dismissed. They won at trial, so the case was dismissed, or the case was thrown out, or maybe they were arrested, but they were never charged. The case was just thrown out. They were arrested and never charged. That's what we're talking about here. Or a juvenile record, right? So a record from when someone was a minor, or if the record has been expunged or sealed or impounded. All right. And this is kind of leading into one of our newest protections. So here's our second poll. So you'll understand why I'm asking this in just a moment. Have you ever heard a landlord say they don't accept vouchers? Also known as housing choice vouchers, also sometimes called Section 8 vouchers. Have you ever heard a landlord say that they don't accept vouchers? And then here's the different options. Many times, a few times, maybe indirectly you've heard it, you're not sure, or you've never heard it. I'm assuming that the poll was launched already, but yeah, Liz, if you could just keep tabs or let us know, share the results there.
We do. Actually, we have quite a few people who've already answered. You guys are so quick. And unfortunately, the majority of folks are saying that yes, they have seen it many times. And then the second largest category of answers is a few times. And then folks, of course, are hearing it from other folks. There's not a ton of people who are saying that they can't recall or they've never heard about it, which is unfortunate, truly.
Mm-hmm. Okay, thanks. Thanks, Liz. So the reason I'm asking this question leads right into my next slide, which is one of our newest protections in Illinois. It became part of the Human Rights Act effective in January of 2023, which is a protection for source of income discrimination. So as of January 2023, it is now illegal in Illinois to discriminate based on someone's source of income, for a housing provider to discriminate based on someone's source of income. And the way that the law defines source of income is the lawful manner by which an individual supports themselves and their dependents. So think about what are lawful ways that someone supports themselves and maybe their families or their dependents. Of course, this is not on there, but employment, right? One way that some people support themselves is through their job, through money that they make from their jobs. But here are examples of other ways that people might support themselves and their families besides from employment income. This is not an exhaustive list. These are just some examples. But there you'll see right at the top, there are vouchers. And that's why I asked about whether you have seen a landlord say that they won't accept vouchers, because that is a type of a source of income. That is a way that people support themselves. Vouchers are, administered through the housing authority. So like through Lake County Housing Authority or through other public housing authorities. And for those who don't know, vouchers are, they are basically like someone works with the housing authority, and it's an agreement between the housing authority gets funding from the federal government through HUD, from the Department of Housing and Urban Development, to basically help subsidize a portion or all of someone's rent who has a voucher, and how much the housing authority will pay part of the rent to the owner of the to the landlord, and then the tenant who has a voucher will pay part of the rent to the landlord, and the amount that the tenant portion will depend on their income. So the general rule of thumb is 30% of your income is what you're paying, is your portion, is how that's calculated. And so the housing authority will calculate that. And so that's why I say sometimes the housing authority, if I don't have any income, then sometimes the housing authority pays the entire portion. So it has been very common for certain landlords to not accept those in Lake County and in other parts of the state. And since that is now protection in Illinois, that landlords can't discriminate based on source of income, that is now a type of discrimination in Illinois. But then there's other examples of here on other types of sources of income, like Social Security, veterans benefits, child support, etc. Other ways that landlords can't treat people differently because of, or refuse to rent to people because of where they're getting their money from to pay their rent or to support themselves and their dependents, basically. So some examples of source of income discrimination, and the reason I'm spending a little bit more time on this one is just because it is newer and it just seems to be coming up a lot since it has become the law. We've just been seeing it a lot. I mean, we're seeing it a lot before, but there wasn't really much we could do about it before it was the law. But here are some examples. I broke it up into 3 different categories here of types of source of income discrimination. So that first category on that left there in that first column there is obvious discrimination. So, right, that's obvious discrimination. You know it when you see it, right? So explicitly telling someone, we don't accept vouchers. We don't accept Section 8. Or a landlord saying, you have to have a job to rent here. We only allow tenants that have jobs. That is obvious discrimination. Sometimes discrimination is not that obvious. Sometimes it can still be intentional, where the housing provider is intending to treat someone differently because of their source of income, but it might not be as clear as, we don't rent to people with this source of income. It might be, we're treating 2 people differently because of their source of income. We're treating people, so maybe they're only running background checks of people who have vouchers. Maybe they're only running credit checks because of only running credit checks of certain people who have vouchers or other sources of income, or they're putting other conditions up. And then that third category there on the right is discriminatory policies. So this can sometimes be discrimination that might not be intentional discrimination. Sometimes it still is intentional, but it doesn't have to be intentional discrimination, but it has a discriminatory effect. For example, Something, if you've ever rented, you have probably seen this, is that landlords will have policies that you have to have in order to qualify to rent there. You have to show proof of a certain amount of income. So three times the monthly rent income. That's a really common one. So for example, say I was looking at a place and the rent was $1,000 a month. And the landlord said, you have to show you make 3 times the monthly rent here to rent there. That would mean that to qualify, I would need to show that I make $3,000 a month in rent. Well, a 3 times the rent policy is going to make it next to impossible for someone with a voucher to ever qualify there. Sometimes it is actually impossible. Mostly it is impossible for someone with a voucher to actually rent there. So even though they're not saying, that landlord is not saying we don't accept vouchers or treating people differently, that's a uniform policy, that policy, that 3 times the rent policy, is going to make it, a person with a voucher is going to effectively be prohibited from renting there because they're never going to qualify there. And then it says they're based on the full portion of the rent rather than a tenant's portion. So remember I said before, with a voucher, the tenant pays a portion, the housing authority pays a portion. If a landlord has a policy, show me that you make 3 times your portion of the rent, that is different because 3 times your portion of the rent. So say if I have a voucher and I'm paying $200 a month and the housing authority is paying the other $800 a month towards the rent, if a landlord says, show me that you make 3 times your portion of the rent, so that would be $600, right? 3 times 200, then that I would still qualify there. So that a voucher holder would qualify. So that's different. These 3 categories here, I use them here when I'm talking about source of income discrimination, but you can really plug in any of the protected classes that we've talked about here and come up with examples. So obvious discrimination based on any of the protected classes, right? Refusing to rent to somebody and just saying, we don't rent to people with children, or we don't rent to people who are African American. We don't rent to, plug in protected class here, right? Obviously, those are refusing to rent to someone because of their protected class. That is a type of obvious discrimination. Landlords can treat people differently, not just based on their source of income, but difference in treatment. So again, these are doing things that are different for people based on their protected characteristics. It can happen with all the different protected classes. It doesn't only mean refusing to rent to somebody because of their protected characteristic. It can also happen in all different points of the tenancy. Running background checks only of, only running background checks of people that are in the military, or only running background checks of people who of a certain national origin, or something like that, or only running credit checks of certain groups and not others, right? So these are, or maybe higher security deposit. That's one I've seen, right? Higher security deposit for families with children. That's one that I've seen before. So again, a lot of these can apply to the different protected classes. Immigration status is another pretty new protection we have in Illinois. It's our second newest one in Illinois. It became new as of January of 2024. And it makes it a civil rights violation for housing providers to discriminate based on someone's immigration status, which is defined as someone's actual or perceived citizenship or immigration status. There's an exception here in that the law carves out an exception for housing providers to ask about immigration status if it's required or permitted by state or federal law. So the example that I can think of, where I think this would probably most often come up, is a property that gets federal funding, like public housing, that you have to be able to, that benefit is only for people who have who are either citizens or who have a certain that are covered under, have a certain citizenship status or residence or other protected citizen status, covered status there. So in that scenario, it would be legal for like a housing authority to ask about someone's immigration status before allowing them to rent there, because that's required by the law. And then finally, the last protection we have in Illinois, reproductive health decisions, is our newest one. It became effective in 2025, which includes decisions related to contraception, fertility treatment, miscarriage, or abortion or related care. And then here I gave an example of a landlord seeking to terminate someone's tenancy after learning that they received some kind of like a morning after pill or some kind of other, or an abortion, had an abortion or some kind of other thing that maybe the landlord was opposed to, like that, with terminating a pregnancy, and decided to terminate their pregnancy. To terminate their tenancy. So that's our newest protection in Illinois. Oh, so here, I just mentioned this before, so I'm kind of going to skip this here, but because I just said this when I was talking about source of income. But remember, with all the protected groups, we got all these different categories. We got intentional discrimination, like explicitly saying we don't rent to someone, or it can be, or threatening someone, interfering, difference in treatment, lying about housing, maybe refuse. So different terms and conditions was the example I gave before, or it can also mean like lying about the availability of housing. Maybe a landlord is saying to somebody, maybe they're not explicitly saying, we don't rent to people because of XYZ, but they're lying to people. They're telling certain people that the housing is available and the other people that it is not available. So, or refusing to rent, like I said. And then other violations, I talked about discriminatory effect. I gave that 3 times rent example. And then finally, another type of violation, a fair housing violation, is refusing to grant reasonable accommodations and modifications. And that brings us to, I think, the last part of what I'm going to be talking about this afternoon. I was going to say this morning, but I guess technically it's after 12. It's the afternoon. So is this right for protection with people with disabilities? And the National Fair Housing Alliance, or NAFA, does a trends report each year where it takes surveys of fair housing complaints that are being filed. It surveys all of its all different fair housing organizations and legal aid organizations that are members every year, and does surveys. What types of fair housing complaints are you filing? And consistently every year, disability discrimination is always at the top. People are always filing complaints based on disability discrimination. And so here you see our latest data from 2025, according to the National Fair Housing Alliance, 54.6%, they estimated based on their survey of fair housing complaints in the US were filed based on disability. And that's really because, and I see it in my work too. I would say, I don't know, I haven't done a calculation, but I would venture to guess that at least 50% of the fair housing cases I see are probably in the disability discrimination too. And that's really because people with disabilities have this extra right that the other protected classes don't have, and that's to have reasonable accommodations and reasonable modifications in their housing. So when landlords mishandle those requests, that is a type of that can be illegal. That's a fair housing violation. That can be discrimination. Remember, I said before, here's a definition of disability. First of all, physical or mental impairment that substantially limits one or more major life activities. So remember, when I'm talking about disability, I'm not only talking about physical disability, I'm talking physical or mental, and it has to substantially limit one or more major life activities. Substantially limit a major life activity means, I think I have a slide here, what a major life activity is. Here's some examples. I don't know if you can read all those on there, but these are just some examples. Caring for yourself, seeing, hearing, eating, walking, thinking, concentrating, communicating, reading. These are all things that you have done some or all of the things on this list just today, probably, right? So these are all things that people do day-to-day major life activities. And so someone with a disability, the disability either substantially limits their ability to do one or more of these major life activities, or they can only do it under very specific circumstances. Either they can't do it at all, or they can only do it they need certain assistance to do it, or only with certain specific, in a specific circumstance. Generally, when we're talking about disabilities that are protected in fair housing law, we're talking about disabilities with long-term effects. So not something like a broken bone or a sprain, something that is long-term or permanent. So what are these rights that people with disabilities have? People with disabilities have two additional rights. They have rights to request reasonable accommodations and reasonable modifications in their housing. A reasonable accommodation is an exception to or a change in a policy. Again, this is to allow them to enjoy their housing, just as someone who is not disabled would be able to more fully to enjoy their housing, or to more fully enjoy their housing. So it's an exception or a change to a policy. And there are just a million different examples of reasonable accommodations that I've worked on. Okay, not a million, but a lot. So I tried to pull some pictures of just a few of the most common ones. These are not the most common ones just across the board, but they're just ones that I've seen more than once. So tried to pull a few that have come up in my work a lot. And the one on the left there, you see somebody with a dog, and that's to illustrate an example of an emotional support animal or a service animal. So, and a landlord that, say there's a landlord that that doesn't allow pets in their property, no pets policy. Well, say I have a emotional support animal or a service animal, and we could talk about emotional support animals and service animals for an hour, so I won't talk too much about them unless someone has a question later. But if I have an animal that helps me with my disability in some way, either as a service animal or maybe an emotional support animal that helps maybe with my, like, say I have anxiety and my emotional support animal helps with alleviate symptoms of my anxiety or depression or other mental disabilities too, I have the right to ask for an exception to that no pets policy as a reasonable accommodation. So I'm asking because my animal is not a pet. It's helping me with a disability. It's a different definition there. So I'm asking for an exception to that no pets policy for my animal. So that's one example of a reasonable accommodation. Another example of an accommodation is illustrated kind of by that second picture there. Maybe that person is helping somebody down the stairs. So a caregiver, maybe adding a caregiver to a lease. Or having a live-in aid. Maybe there's a better example. A better example is, a lot of leases have rules about overnight guests, that you can only have someone staying overnight up to, I'm just making this up, 14 nights a year as an example. Well, what if somebody has a disability and they need an overnight guest, not someone that they need to live with them, but they have, because of their disability, they need someone to stay overnight certain times when something is flared up, or certain number of nights a week or something. So they're asking for an exception to that policy in the lease, that overnight policy. Or so that's an example of a reasonable accommodation there. That third picture there, reserved parking space, another one that I've seen several times, a lot of times. Maybe there's an apartment building that doesn't have reserved parking spaces. It has a parking lot, but it doesn't have reserved spots. And somebody with a disability needs, because of they have trouble, maybe they have some kind of mobility impairment, difficulty walking, they need a spot guaranteed for them as close as possible to the entrance of the building. So even though that landlord has a policy, they don't have at their complex, they don't have reserved parking spaces, that person asks for an exception to that rule and to ask for a reserved parking space for them as close as possible to the front of the property as a reasonable accommodation. Those are just three of many examples But that's what a reasonable accommodation is. Reasonable modifications, remember I said there were two rights of people with disabilities, their rights to request accommodations or exceptions or changes to rules or policies because they're somehow related to the disability. And then the other one is modifications, which is a physical change to a property. And here are a bunch of examples of physical changes that can be made to someone's property. Again, this is not an exhaustive list. These are just examples, right? Making a bathroom accessible. You can see a walk-in shower, grab bars, floating vanity, widening a doorway to get a wheelchair to fit through, a ramp, a fire alarm that not only makes noise, but maybe lights up. These are all examples of physical changes to the property, that someone with a disability might need. Tenants' duties here. So with reasonable modifications, a housing provider can require that before someone makes a physical change to the property for their disability, that they get permission, get assurances that it's going to be done professionally with permits if required. Sometimes the landlord can require that the unit be restored to its original condition unless the change won't affect the next tenant's use. So I think if someone widened a doorway and then to get their wheelchair to fit through, I don't think in that case it would probably be reasonable it would be unlikely that it would be reasonable for a landlord to then say, well, when you move out, you have to then make the doorway more narrow, because is a few inches of a wider doorway really going to affect the next tenant's use? Probably not. Never say never, but probably not. But there are certain things that it might. Maybe a tenant has lowered cabinets down to make them reachable for someone in a wheelchair. Could those lower cabinets, could that affect the next tenant's use of that kitchen? If in those kitchen cabinets, if they are not in a wheelchair, yes. So that in that case, it could. So in that case, it might be reasonable to do that. Now that last point, we always put that at the end, but I feel like it probably should be bumped up to the top, because I think the thing that most people are wondering about first is who's paying for these, because modifications can be very expensive. And so who's paying for it? So usually it's the tenant is responsible for paying. The landlord is required to allow the tenant to make the physical change, to make the place accessible, or do the examples like that I showed you on that last slide. But almost always they don't have to pay for it. It's still on the tenant to actually pay for it. The only times that the landlord is responsible for paying for it is if it's in a federally funded housing. So like public housing that's owned by a housing authority, public housing, or subsidized housing. So housing that receives HUD funding, federal funding that way. In that case, the housing provider is usually on the hook. But in most contexts, if it's private housing, or even if it's someone that's using a voucher with the private landlord, it's on the tenant. The landlord has to allow the change, but does not have to pay for it. So here are kind of the key elements of a reasonable accommodation request. Housing provider accommodation or RA/RM, reasonable accommodation or reasonable modification request. So for either of these things, making an accommodation or a modification, a housing provider has to know that the tenant has a disability. Okay, so they either know because the disability is obvious, or because if it's not, the tenant has to actually tell their landlord that they are disabled. The housing provider has to know that the tenant has a disability. The request, what the person is asking for, has to be necessary to address the effects of the disability. So it has to somehow be tied to their disability, right? They're asking for this change for the ramp because it somehow helps them with their disability get up to the front door. They're asking for that exception to that no pets policy because they need an emotional support animal, which is to alleviate the effects of their mental disability. It has to be a connection. The number 3, the tenant has to actually make the request or the need is obvious. So in some situations, maybe that it's an obvious connection where the landlord might already know on its face what the tenant needs. That doesn't come up that often, but I guess the easiest example I give for that is like a person with a wheelchair needing a ramp when there's a front door with steps. Maybe in that case, that would be an obvious need. But most of the time, landlords are not mind readers and do need to have, and the tenant has to actually make the request and explain to the landlord, number 1, that they have a disability, and number 2, what they're asking for and how it's tied to their disability. What they're asking, they have to make the request and they have to explain the connection between the request and their disability. It has to be reasonable. Remember that word reasonable was in the term, right? Reasonable accommodation, reasonable modification. It cannot impose an undue financial or administrative burden on the landlord, and it cannot require them to alter the nature of their services. And I think I have a slide on each of those to explain what each of those could look like. But basically, there are situations where a housing provider, a landlord, can deny a request if they can show that it's burdensome, if it's a financial burden on them or an administrative burden on them, or it's somehow they have to alter the nature of their services. Like I said, I have an example of what that can look like in just a moment. And then finally, there's no direct threat. So this means that the landlord has to grant the accommodation, or as long as there's no direct threat, which means a threat to a health or safety threat to other people or to the property. And what I mean by that is here, I have it on this next slide here. Direct threat means health or safety of others or the property of others. And no other accommodation will eliminate that threat. So what do I mean by that? I mean, in narrow circumstances, a landlord can deny one of these requests if they can show that if they grant it, there's going to be some kind of an issue here, a health or safety issue, either to other people or to property. And like I said, there's no other accommodations that will eliminate that threat. So going back to my example with the emotional support animals, if we have an animal that someone's asking for an exception to that no pets policy, and we have an animal that has attacked someone or bitten someone, that might be a case for not allowing that animal in the housing, even though it's an emotional support animal, because that could be seen as a direct threat to the health or safety of others. But again, we have to be able to show I say in narrow circumstances, because in denying the request, saying that there's a direct threat, the landlord has to be able to show that there's no other accommodations that would eliminate the threat. So, I mean, again, using that same example, maybe there's an accommodation that can eliminate that threat. Maybe there is a dog that was aggressive, and then I guess I'm trying to think off the top of my head, maybe the tenant, maybe the landlord says, well, your dog is dangerous, or we've had reports that your dog is jumping on other people. We will allow you to have that dog if you can show us that the dog is now, you've done training with that dog, so they're not going to do that. Or maybe if there's some kind of a risk of that the dog has bitten someone before, maybe one way to eliminate that threat would be requiring that the tenant, okay, you're allowed to have that dog, but if you're taking that, if anyone is coming into your unit from the property, like a maintenance person or anyone else, or you're taking that dog outside of your apartment building, it has to have a muzzle on it, something like that. And finally, when we're talking about reasonable accommodations and modifications, housing providers have to engage in this ongoing discussion or dialogue when they're evaluating these requests, or what we call in the law sometimes an interactive process, meaning that even if suppose I made a request for my emotional support animal, or for, I don't know, whatever my request was, and I didn't provide any proof that I had a disability or anything to support my request. I just made the request outright. Can the landlord then just turn to me and say, it's denied because you didn't show me proof that you were disabled, or explain proof from explaining your need for this animal? No. They have to have, it's an ongoing dialogue. Just think of it as it's an ongoing dialogue. There's a duty by the landlord, the housing provider has a duty to have this ongoing discussion with the tenant when they're evaluating these requests, these accommodations or modifications, even if maybe the person making the request hasn't provided enough documentation, or maybe what they're at, or maybe they can't actually maybe they can't actually accommodate the person, like do what the person's asking for. So maybe I am in an apartment building that doesn't have an elevator, and I'm on a second floor apartment, and it's because of my disability, it's become much harder for me to climb the stairs. And so I'm asking in the middle of my lease, I'm asking if I make an accommodation request to move to a first floor unit. In the middle of my lease, can you transfer my lease to a first floor unit because I can't climb the stairs anymore? Well, what if there is no first floor unit available? What if they're all full? At that point, does the landlord just say, well, no, we're denying your request because we don't have a first floor unit available, so sorry, denied? No, even if the accommodation can't be granted, what the person's asking for, again, it's always this ongoing dialogue. Is there something else that the landlord can do to somehow accommodate them? So maybe they can't get them exactly what they're looking for, but in like that scenario, maybe there's something else that they can do. Maybe they can say, well, we can't give you what you're asking for, but we can't because our first floor units are all full, but maybe we can, we have a wait list for first floor units, and we'll put you at the top of the wait list. So the next time a first floor unit becomes available, you're number one on the wait list. You'll be the first one to get the next unit available. Or we understand that you need a first floor unit. If you can't, we are willing to allow you to break your lease early without penalizing you, so that you can find another unit somewhere else. Or once you find somewhere else in a first floor unit in another building, we'll allow you to break your lease early without penalizing you for it as another accommodation. So again, these are just some examples, just to remember that there's this ongoing dialogue, that the landlord has this responsibility for this ongoing discussion. It's not just a one request and answer. If it's no, there's to have this discussion to see if they can reach some kind of an agreement. So I'm going to just rush through these really quick to get to Jen, so we don't run out of time with Jen talking about testing. But remember, I gave some, actually, no, I just gave this example. So I forgot I had it on the next slide. So here's your visual to go with my stairs example. Okay. I gave an example. I mentioned before an example of financial burden. So what if as a way that maybe a landlord might be able to deny an accommodation request. So tenant with a disability can't take the trash out to the dumpster. So they ask the maintenance person to come to their apartment to take the trash out to the dumpster for them. How should a landlord respond? And if we had more time, I might have you put in the chat how you would respond to that. But in the interest of time, I'll just give you some ways that I think that this could go. So someone with a disability, can't they take their trash out to the dumpster? So they're asking the maintenance person to take the trash out for them. The reason I put this on a slide as an example of a financial burden is because, well, that there might be an argument that a landlord makes that we can't, that is a financial burden for us because we have a maintenance person, we're paying them hourly, we have all these other jobs that they have to do within these certain hours, and we cannot afford to have them while they're working take their time out to do this when they have all these other duties, to come to your unit and take out your trash for you. So they might be able to argue that there's some kind of a burden on them. But again, remember, there's this interactive process, right? Responsibility. So even though there might be an argument that a landlord says, well, we can't allocate someone to come out to your apartment every week to take your trash out to the dumpster for you. Maybe there's something else that they can do. Maybe they can say, well, we can't come every day, but we can come out every week or once a month, or we can't have someone that takes the trash out for you, but we can put maybe a smaller garbage can closer to your unit that then we empty that one. So we understand you can't take your trash to that bigger dumpster, but maybe they put a trash can somewhere else. There's lots of different ways that it could go, but the answer is so again, like everything else, it just depends. All right, so that is all I have for reasonable accommodations and modifications. And now I'm going to turn it over to Jen to talk about fair housing testing.
Hi, everybody. Thank you, Maya, for all that information. And I just want to let you know I emailed you the questions out of the chat, so they're in your work email, so you can answer them when I'm done here. So you don't have to hunt through all the chat there. So I'm going to talk a little bit about fair housing testing and what it is. We do have the Fair Housing Project here at Prairie State. You can go ahead and switch the slide there, Maya. So part of the testing that we do is we test basically any housing provider. So we can test landlords, realtors, mortgage people that provide banks that provide mortgages, and home insurance companies. So we do all the different types of testing. Testing is the tool that we use to identify housing discrimination. And we basically have a volunteer staff, or people that do act as secret shoppers. They pose as renters or buyers, and then we compare their test reports to see if they are treated the same like in a similar situation. So this testing allows us to see what's really happening, and it's not just what's reported. Go to the next screen there, Maya. So why do we do the testing? Because in today, before, people could be very blatant with their discrimination, but of course now there's laws in place, but that does not mean that the discrimination has stopped. So landlords or many other housing providers have learned to be more subtle or hidden with the discrimination, and that's why testing is so important. If we didn't have testing, we would never be able to detect this discrimination. So another reason is many people don't file complaints. We do education as well, like today, because sometimes people don't even know that they're being discriminated against because they don't know their rights. So we do like to, at Prairie State, give that education and also let them know about the testing program. A lot of times different treatment can go unnoticed. One example, you go and look at an apartment and you see the sign outside and you're like, oh, this is great, I want to move here. And you put in an application and they tell you it's rented. But let's say your friend goes and they're white, and then all of a sudden it's available to them. So that would be a different treatment, or something that you wouldn't notice on your own, because it's on your own you would never see that. But when you had someone go that was different than you under a different class, then you could see the differences. So testing helps uncover these patterns. And like I said, without the testing, a lot of the discrimination that we uncover would never be detected. So testing helps us capture these patterns or practices that are happening, and it's not usually just one particular interaction, unless it's very egregious. But most of the time, we look at it more than once. Is this just like a fluke situation? Did something happen that was maybe, someone was in there like a substitute and made a mistake? Or is it something that they continually do? And when we see that they continually do the same thing, then we realize that there's an issue, and that's when the legal team can go in and take a closer look at it. So basically, what we do is we send out two or more testers to the property with similar qualifications. And then we only have basically the one key difference would be their protected class, either the federal or state, because we do both. And then we would compare their test reports. Go ahead, Maya. You can go. Okay. Um, so what does testing do? It supports investigations and legal cases. It identifies the discriminatory practices, it promotes accountability, and it helps ensure equal access to housing, which is our main goal. Um, and this testing turns suspicion into evidence. So it's great, and it helps the legal team with a lot of their cases. It also, identifies the problems that we're finding. So it's very helpful. You can so how can you help with testing? As I mentioned in the chat, if you suspect discrimination, maybe you saw an ad or you've experienced it yourself, you can coordinate with our teams. You can help identify these opportunities and give us tips or concerns, and you can email those to Paris Brandy. And then he will review them with the testing team, and then we will decide if we're going to go further and test these properties that you're finding issues with. Testing helps ensure that fair housing isn't just a law, but it's a reality. So also not just giving in tips and issues that you found on your own, you can also become a tester, and that would be great. You must have a state issued ID. You have to be authorized to work in the United States. You have to have access to transportation and a computer, and you cannot be a landlord or licensed real estate agent. That would be a conflict. But if you meet these requirements, we would love to talk to you about becoming a tester. You can go to the next slide, Maya. So when you become a tester, you will be trained. You will learn report writing skills, and you also will receive a compensation. So you'll get a small stipend for the work you complete, along with mileage if you drive to and from the assigned location. Most importantly, you're going to be able to help your community become more inclusive and welcoming. So if you are interested in becoming a tester, you can email fairhousing@pslegal.org, and then I can send you an application and further documentation to fill out. Go ahead, Maya. And Maya's going to talk about complaints and relief, and then we can talk about answer some of your questions.
Okay, thanks. I was frantically reading through as much as I could of the chat while you're doing that, so I could be prepared to dive right into some questions. So I'll just spend like a minute on this last part here. So what are some ways, if you feel like you've been discriminated against, what are rights that you have if you feel you are a victim of discrimination? What are rights that you have? You can file a fair housing complaint in an administrative forum, and that means either filing with HUD, Department of Housing and Urban Development, or in Illinois, we have the Illinois Department of Human Rights. Those are both agencies, a state and a federal agency, that investigate fair housing complaints, allegations, and it's an investigative process where if you file a complaint, it gets assigned to an investigator. They do a whole investigation. And then if they find that there's enough evidence of discrimination to go forward, then at that point, it's a long process. It can take over a year. But after that investigation, if they do find that there's enough evidence to go forward with a discrimination complaint, then it actually goes before a judge, not a state court judge or federal judge, actually a judge in an administrative judge, either a judge at HUD or a judge through the Illinois Human Rights Commission, and it kind of operates similar to court at that point, and is litigation like that. There's a 1-year statute of limitations, meaning that the complaint has to be filed within 1 year of when the most recent date of the discrimination happened. It can take a long time. It is free to file, pro se friendly. It's not a terribly hard process to actually file the complaint. You can find information on both of their websites on how to do it. You don't have to have an attorney, and it's pretty easy to navigate filing the complaint even without an attorney. The other option is to file in court. It's to file in state or federal court. There is a longer statute of limitations, so filing complaints in court can be done within 2 years of the most recent date of discrimination, so a little bit more time. There's usually court costs. There's usually filing fees, unless that you can get a waiver from the court. For certain people can, if ask the court to waive those fees if they're below a certain income. There are certain benefits to each way. There are certain things that you can ask for in court that you can't ask for in the administrative forum, like punitive damages, things like that. You can do both at the same time up to a point. We won't get into the details in the interest of time, so I have time to answer some questions. What are some things that you can ask for? If you're filing a complaint, what are things you're hoping to get? Maybe what are some of the remedies you're asking for, right? Maybe to keep your housing or to get into housing that you were otherwise not allowed to get into, or a policy change. Maybe a landlord has a policy of not allowing certain people and you're asking for that policy to be changed. Monetary damages is a really big one. So like emotional distress damages or lost housing opportunity. Maybe someone was denied housing or discriminated against. Discrimination cases can often involve a lot of emotional distress for people, depending on the situation. So that's something, compensation for that, or housing opportunity. Maybe someone was denied housing and they ended up having to move somewhere else that was less desirable, more expensive, had to spend money moving, things like that. And then, like I said, there's other things that you can ask for as well. That's mine and Jen's contact information. As I said, I promise you I'd put it up there at the end. So there's our names, our email addresses, phone numbers, website. I will leave that up there in case you want to jot it down while I take a few questions. Like I said, I'm sorry, I won't. Oh, yeah, go ahead. Sorry, go ahead, Liz.
It's beautiful. So I think what we should do, I'm going to keep the workshop open. I know Zoom gives us a certain amount of time, but we'll keep it extended if anybody wants to stick around. Obviously, I know folks have to leave at 1:30. We are recording this. So what I'll do is I'll go through what we have in the chat, and obviously the ones that have been answered I won't read to you, and then you can respond to that and then take questions. My recommendation to everybody who wants to ask Maya a question, if it is a very personal thing, let's go ahead and email that instead of asking it in the group, because one, we don't want to out ourselves on the internet. This is recorded. And then two, a more specific, really detailed situation is probably better helped by attending